the judges Lee and Bernhardt.
Please be seated.
Case before the court, matter of competing states, Laurentia and Caledon. The applicant and respondent to for each allocated 45 minutes to present the respective.
Welcome. We are here to hear the case of Laurentia against Caledon, and when the applicants are ready, the court is ready to hear you.
Where they have been in fact unlawfully retained in that state. And second, that Caledon is also bound under international law to pay damages for the pain and suffering that these children have been subject to. My co-agent will address this court with the issues concerning the Save the Children Act, the position of the import ban, and the enforcement of the Daughters of Children Foundation judgment. We will be saving 3 minutes for our rebuttal, Your Excellency. If the court allows me to begin with my first argument. Your Excellency, it is a submission on behalf of the state of Laurentia that the state of Caledon has unlawfully retained the children of the state of Laurentia. The state of Laurentia is not arguing the removal of the children, for it has in fact thanked the government of Caledon for its help in providing humanitarian assistance in time of need. However, what cannot be accepted and is contested before this court, Your Excellency, is the fact that these children have been unlawfully retained in the state of Caledon.
Is the circumstance that the children were rescued from a very serious natural disaster and cared for and paid for by the state of Caledon and its nationals of relevance to your argument?
Your Excellency, the only point that you have raised that is relevant to our argument is the fact that we have thanked the government of Caledon for such conduct. What is contested, however, is that their assistance cannot change into an unlawful retention when the children have been in fact asked for by the state of Laurentia. I would like to remind this court that the state of Laurentia gave back 2,600 children to the state of Laurentia. The state of Caledon gave these children, Your Excellency. However, it was at the moment that the state of Caledon refused to give these children back that immediately the state of Laurentia acted upon and requested these children, not only once but twice.
Why was the state of Laurentia the legal guardian of the children? Why couldn't the state of Caledon take the position that in the best interest of the children, they should remain in safe homes where they were until a natural parent came forward and expressed an interest in them?
Your Excellency, because as this court has pointed out before, in the 1993 case concerning the application of the Convention on the Prevention and Punishment of the Crime of Genocide, it stated that the right of parents patria exists, and this has been ratified in the Convention on the Protection of Children and Cooperation in respect of inter-country adoption, the European Convention on the Repatriation of Minors, and the Inter-American Convention on the Return of Children. State practice shows that it's the state of whom the nationals is that has the right to exercise parents patria, as it has been done before in 1938 by the Spanish government in requesting its children.
So are you arguing that the state of Caledon had no responsibilities with respect to these children while they were within its territory?
Yes, Your Excellency, it does. It has the responsibility to bear upon the best interest of the child. However, the adoption proceedings that took place in the state of Caledon are inconsistent with such principles. For the Convention on the Rights of the Child states clearly in its paragraph 12, Article 12, paragraph 2, that the child has the right to exercise its opinion in judicial proceedings. However, the state of Caledon did at no time request the opinion of the child, Your Excellency. And the only thing that it did was send a letter to the parents where an address was provided. It did not sought consent neither from the state of Laurentia, neither from the natural parents, Your Excellency.
Agent, before you go into more details, can you explain to the court, you have invoked a number of international legal instruments in the field of protection of children. Can you tell the court that these instruments which you have referred to, you seem to imply they are applicable to the circumstances. Can you tell the court, are there any legislative history that could support your statement that indeed these instruments are intended to apply to a situation of this kind, where you have a massive children involved, and whereas these instruments, it seems to me, they deal with individual normal cases rather than a eruption of a volcano, and as a result you have hundreds of children get involved, and that these conventions are also applicable. Can you give us some legislative support in your assertion?
Your Excellency, there is no legislative support as to my knowledge. However, the fact learners in paragraph 27 that all states are parties to the Hague Convention on the Civil Aspects of International Child Abduction. Though this treaty that is binding upon the respondent state, the state of Caledon has the duty to repatriate the children for the place of habitual residency before the natural disaster occurred was that of the state of Laurentia.
You're not answering my question.
Your Excellency, with all due respect, as far as I know, there is no legislative issue concerning natural disasters. There is, however, a guideline issued by Everett and Ressler in joint statement with the United Nations High Commissioner for Refugees and the UNICEF found that deals with matters of natural disasters. In this case, it states that adoption proceedings should take place only after 2 years have passed. And in this case, Your Excellency, the government of Caledon, however, gave the children in adoptions before this 2-year period, even though it is not legally binding. Everett and Ressler is considered to be one of the main authorities concerning children's rights in movement and in natural disaster circumstances, Your Excellency.
But nevertheless, you still claim that these conventions, the CRCs, the CCA and CCIA, they are applicable in the present case.
Yes, Your Excellency, I do see your concern that perhaps the respondent state will try to argue that they're not applicable. But I would like to draw the court's attention to 2 important facts. First of all, the Hague Convention on the Civil Aspects of International Child Abduction was intended to protect children from wrongful removal or retention. This is a case of wrongful retention, Your Excellency. In that case, it applies. It also states that in the convention, it is established clearly that the state shall take all the measures necessary to protect the welfare of the children. Therefore, it's also applicable. And concerning the Convention on the Rights of the Child, the state of Laurentia is not including or invoking this convention. For the acts in this present case that the court is hearing here today are continuous in nature, and therefore the convention must be applied. In Your Excellencies, I would like to remind this court that under the principle of the best interest of the child, every single convention that may be applicable to the case should be considered.
But
You have, sorry.
I was going to ask you a question. Under these conventions, we can speak of the best interest of the child, but there are actually 2 opinions here about what is in the best interest of these children. One opinion held by the state of Laurentia and the other by the state of Caledon. And the children are actually located in the state of Caledon now. Now, I take it that the state of Caledon has, in fact, a responsibility to take into account whether sending the children to a different country would be in their best interest.
Madam President, if the state of Caledon had actually taken into consideration the best interest of the child, it would have returned the children immediately.
Why do you say that? They say that they did, and I'm not sure that we can say they didn't. Now, perhaps if there's some legal priority that the state of Laurentia has, that might be a different matter. But simply to say the best interest of the child doesn't tell us whose judgment we should defer to on that question.
Madam President, you have pointed out precisely the issue. The state of Laurentia has a legal priority to determine the best interest of the child. For under the Hague Convention on the Civil Aspects of International Child Abduction, it is the state of habitual residency, the one that has the right, the duty, to determine what is in the best interest of the child.
Even though you agree that the children's original movement into Caledon was something that was appropriate under the circumstances, and Caledon at that moment developed responsibilities toward the child.
Yes, Your Excellency. However, what it is contested is not the wrongful removal, but the wrongful retention. And the convention applies to both circumstances. It says the retention retention or the removal. And in this case, it's a case of retention.
Oh, I understand that, but I think the question I have is whether, in deciding whether a retention is wrongful or not, the abduction convention or any of the other conventions that you've referred us to require us to disregard Caledon's, or the territorial state, I will say, the territorial state's evaluation of the best interest of the child.
Well, Your Excellency, if this court were to determine what is in the best interest of the child, the conclusion would be even, and it is that the children would be better off in the state of Laurentia. In the 3 years that have elapsed, circumstances have ameliorated in the state of Laurentia, and therefore there is no immediate danger in returning the children to Laurentia. The convention establishes that the child must be returned unless there is great risk that with the child returned, it would damage its own well-being. Your Excellencies, I would like to remind this court that in the compromise, nowhere it is established that the children have in fact actually settled in their new environment. The only thing that we know from the record is that these children have not been subject to abuse by their parents. Your Excellencies, these children could not have settled in their new environment, where they have been in 3 different places in 3 years. First of all, they were in a medical facility, then they were in prospective adoptive families, and now they are in certain adoptive families where their opinion was not even asked.
But these are very young children, we know from the compromise. We know that they are 14 and under, or under 14, is that not correct?
Your Excellency, the ages vary from 0 to 16 years of age.
So for a child who was 5 years old, to move back to another country might be a very disruptive matter.
Your Excellency, perhaps, but for a child that is 14 years of age has the right to let the court know whether or not he wants or she wants to stay or not.
Under what law?
Under Article 12, Paragraph 2 of the Convention on the Rights of the Child, what the respondent state has not taken into consideration, Your Excellency. Furthermore, the respondent state has...
But Article 2 can't mean that children, no matter how young, have the right to express their opinion. As you said, 0 would be very difficult to ask the child what it thought.
In fact, Madam President, that is why according to the age of 14, because it's usually state practice in different legislations of the world that point out to that age or lower. But the convention does not give a specific age, Your Excellency. What it states is that the child should be allowed to give his or her opinion when it is able to form his or her own opinion, Your Excellency.
And what evidence do you have in the adoption proceedings, which Caledon has argued were very thorough, that this opportunity was not provided?
Your Excellency, for record, shows that the only thing that Caledon did was consult a list from where the child's name was extracted, and that the Children's Foundation gave its judgment. However, the children's opinion was not contested. The court cannot infer that every child was 0 years of age, Your Excellency. There certainly are children that are capable of forming his or her own views, and that have the right under the Convention on the Rights of the Child, to which the respondent state is bound, to have their views heard, Your Excellency. And this was not provided under the adoption proceeding in the state of Caledon. Moreover, Your Excellencies, the state of Caledon has used inter-country adoption as a first means, even though the Convention states clearly in Article 12, Paragraph B, that inter-country adoption should be used as a last resort.
They used foster care first, though, before they did inter-country adoption.
Yes, Your Excellency. However, the Convention states clearly that inter-country adoption should be used as a last resort when the children cannot be placed within their country of origin. And this has not been taken into consideration by the respondent state.
Now, what duty under these conventions would you say this court should find Caledon had in order to track down what must have been a very difficult job of tracking down family members? Both how much should they have spent, how hard should they have looked, and how broadly through the family does international law require them to look?
Thank you for asking me that question, Madam President. I would like to satisfy the court concerning that matter. The 51st report of the United Nations High Commissioner for Refugees that calls upon measures such as taking photographs and showing them in marketplaces, mediating with the Red Cross, taking videotapes and airing them in the countries of origins where the children came from. However, the government of Caledon did nothing of the sort. It only gave a vague list. The respondent state will try to argue that the list was good enough for 600 parents to claim the children. However, in the compromise, it is stated clearly that the children help in providing a certain match between a child and a parent, Your Excellency.
Assuming you'll be very successful in convincing the court to return the children to you, can you inform the court what kind of preparation have you done in order for the repatriation of these children in ascertaining what are the best interests of the children? For example, where are you going to have them located? Have you found already the candidates or families to take care of them? Or what kind of system do you have? What kind of preparation have you made for these children?
Your Excellency, with all due respect, the compromise are clear on that basis. However, it would be an outrage for the state of Laurentia to come before this court and not have sufficient evidence that the best interest of the child lays within its country of origin. The state of Laurentia will exhaust whatever measures it has to find a parent when the children are given back to Laurentia. It is impossible to find a parent if we don't know who the children are.
Can you tell the court that you will be able to feed the children and to school them and to house them and to find family for them?
Yes, Your Excellency. And I will tell you why. Because if this court agrees with me on what I will try to submit, is that the respondent state will have to pay moral damages to every child who was unlawfully retained in the state of Caledon. And therefore, there is enough evidence where the judgment of the court in the favor of the applicant state that enough money would be provided for every child to be taken care of. And this state has
Paid for still by the state of Caledon.
Your Excellency, because the state of Caledon has a duty under international law to repair the wrongful that they did.
Will there be an offset against that duty for what they've paid for the last 3 years to sustain those children and for what they paid in the disaster relief?
Your Excellency, Madam President, with all due respect, it would be for this court to decide. However, that would be a matter that can be assessed by the expert witnesses, taking into account Article 50 of the statute of this court and the decision granted by this same court in the Corporate Channel case in 1949. However, it is difficult to point out how much a life is worth. The government of Caledon did the humanitarian assistance on its own free will. However, what cannot be accepted by applicant state is that this humanitarian assistance has translated, in fact, into an unlawful retention that is condemned under international law and by a treaty that the respondent state is party to, Your Excellency. Therefore, the applicant state can submit before this court that the means of inter-country adoption is in clear violation of Article 21, paragraph B of the Convention on the Rights of the Child.
Do you have any preparation planned to take care of these children if they do come back?
Yes, Your Excellency. The government of Laurentia will have immediately rights of custody of these children.
No, do you have any concrete measures or plans for the repatriation?
It's hard for me to see on a best interest of the child basis how we can be sure this is a better outcome for the children.
Your Excellency, it is a better outcome for the children because the Convention on the Rights of the Child establishes two rights that are of fundamental importance for this court to give its opinion. The first of which is the right to family unity. There is enough evidence in the compromise that perhaps family members will come forward to claim the children. I would like to point out at this time that respondents will try to argue that no natural parents came forward to claim the children. However, let it be reminded this court that it is impossible for a parent to claim a child when such little information has been given by the state that has the duty under international law to comply.
What kind of efforts have you made in order to ascertain the relatives or parents of these children, of these 400 children that you wanted to get back?
Your Excellency, Your Excellency, with all due respect, I would like to answer your question with another question. How can you find a parent if you don't know who the child is? Therefore, given the insufficient data provided by the respondent state, it is impossible to find out who the parents are. It is upon the state of Caledon that has the duty under international law to let the parents know who the children are and to let the state of Laurentia know who these children are, Your Excellencies.
Can I ask you one more question before you go? Your time is up. Do you think the International Court of Justice is the appropriate court to deal with, for example, the question of the interest of the child, given the fact that the court deals primarily the interest between the applicant state and the respondent state. Could you elaborate on that?
Well, Your Excellency, given that both states have submitted to the jurisdiction of the court by special agreement and have brought the matter to be discussed here, it is the appropriate forum. However, if the respondent state had returned the children where they should have, it would have been within the domestic courts of Laurentia to institute what is in the best interest of the child, where everybody would have had a right to speak. The state of Caledon, giving appropriate legal counsel, the adopted families, and whoever wanted to come forward to bring the claim.
You're not saying the state of Caledon would have appeared in the Laurentia courts, are you? Please finish the answer to the question.
I'm very sorry, I did not hear the...
I understood you just now to say that if the children had been returned, there would have been a Laurentian court proceeding in which parents or other family members and the state of Caledon would have appeared in the Laurentian courts to discuss the best interest of the child. I just wanted to be clear about what you were arguing.
Well, Your Excellency, because everybody has a right to be heard.
But it would be very odd for the state of Caledon to adjudicate its interests vis-a-vis the state of Laurentia in a Laurentian court.
Well, Your Excellency, in any case, the persons concerned, which are the adopted families, would have had a right to come forward to the Laurentian courts and request what is in the best interest of the child. However, since the parties have agreed to come before the court under a special compromise, this court has the right to adjudicate on the matter. If I can be of any further assistance, Your Excellencies.
Thank you very much. We'll now hear from the other agent for Laurentia, Ms. Hernandez.
Good afternoon, Your Excellencies, Madam President. My name is Ana Maria Hernandez, and I'm an agent on behalf of the state of Venezuela. In my presentation, I will be addressing this court with three main issues in particular. First, that the Save the Children Act is consistent with international law. Second, that Caledon was bound to enforce the Dover Children Foundation judgment. And third, that the imposition of the import ban by Laurentia on Caledon was in accordance with international law. Referring to my first submission for Your Excellencies, and that is that the Save the Children Act is consistent with international law. The state of Laurentia acknowledges the fact that the Save the Children Act is extraterritorial, since it condemns action, in this case the adoption, that took place outside its territory in Caledon, having clearly described that it is not unlawfully extraterritorial.
What's your best basis for extraterritorial jurisdiction here? What's your strongest argument, in your opinion?
Well, Your Excellencies, it is a submission of the state of Laurentia that to consider the extraterritorial extension of jurisdiction, we will have to go backwards and see the Lotus case, under which it was established that the extraterritorial extension of jurisdiction was permitted unless there was a limit that restricted and enforcement jurisdiction of the state. And this is the case of Laurentia, since in the present case, Laurentia's restrictive and enforcement jurisdiction has not been restricted by precise international rule.
But there are a great number of other instruments in international law that suggest that, first of all, the Lotus case with its application on the high seas didn't present this kind of a conflict between states. And secondly, that there is some sort of reasonableness limitation to the exercise of jurisdiction if you're speaking now of a kind of effects jurisdiction based on territory. Would you care to comment on that?
Certainly, Your Excellency. Thank you for going to this out, because under these principles, the state of Laurentia would definitely have jurisdiction to prescribe and to enforce the Save the Children Act. Under the effects doctrine, Laurentia's jurisdiction or Laurentia's extension of jurisdiction would be permitted under international law.
Are you claiming that this is permitted under customary international law? Because in fact, when countries have attempted to assert jurisdiction on the effects theory, there have often been very strong objections from other parts of the international community, which suggests that while it may be a position of some countries, it may not have attained the status of customary international law.
Well, Your Excellency, it is a submission of the state of Laurentia that the effects doctrine would have to be considered under Article 38, paragraph 1, subsection C, as a principle, Your Excellency. And to extend its jurisdiction outside its border to regulate activities conducted outside its territory if these activities have in effect within the territory of the state claiming jurisdiction. This is certainly the case in dealing here, Your Excellency, since the actions taken by the state of Caledon have had a clear effect in the state of Laurentia.
What kind of effect? Surely not. I mean, usually this is used in economic areas where there's a cartel overseas that's hurting the consumers of a country, or there's some other effect. Here, surely, on your theory, Caledon would have an equal claim to jurisdiction over these children, since the territorial state always has a claim to exercise jurisdiction. So at best, can't you come up with just a conflict of jurisdiction?
Well, Your Excellency, it is a submission of the state of Laurentia that this doctrine of effect doctrine has been applied in several cases, as for example the Charles Melton case, which was the United States versus Canada, and accordingly, that is, to the effect of it, Laurentia has jurisdiction. For the present case, these adoptions have affected Laurentia's notion.
But that's really not an effects theory in a way. I asked you to begin with what you thought your strongest argument to support Laurentia's jurisdiction was, because in your memorial you argued several different theories of prescriptive jurisdiction. Do you think effects is the strongest point you have?
No, Your Excellency. I think definitely the strongest argument would be first that the Rudolf case established that everything that was not permitted, was not restricted under international law was permitted. And therefore it would be for the state of Caledon actually to prove this court that this Children Act is indeed, since it is assumed under international law that all convicts are accepted unless they are restricted by precise international law.
But does that get you as far as you need to go? Because suppose the state of Caledon, for the sake of argument, said, sure, we have a broad effects doctrine. We're not challenging the actual passage of the law, but it creates a direct conflict with our legislation, and there's another principle that the territorial state takes precedence over the state that's merely making an effects argument. Wouldn't that be enough to defeat your claim?
Well, no, Your Excellency, because then we have to consider the principle of reasonableness. Because in the present case, the state of Laurentia doesn't arrive at the fact that both states could have valid basis for jurisdiction in the same matter. Because the variety of connecting factors, more than one state may have valid reasons to claim jurisdiction. And it is therefore, Your Excellency, that international law has developed several principles in order to evaluate the sufficiency of a state's jurisdiction. And superior among these principles is the principle of reasonableness, which requires a state to weigh various factors in determining the rationality of its jurisdiction.
Agent, could you inform the court, are you aware of any more recent case, for example, in North America, where a state extended its national laws extraterritorially, and what kind of reception this extension was received? More recent case.
Well, Your Excellency, I believe you're speaking of the Heidelberg law.
Well, I'm listening.
Okay. Well, I would be pleased to know that this issue, Your Excellency, since I am sure my learned acquaintance of the state of Caledon are aware of this. The European Commission withdrew that this was yesterday, Your Excellency, regarding the Heidelberg issue, their complaint on the GATT for the Helms-Burton, and they were only dealing with certain details of the Helms-Burton law regarding the visa, the denial of the visas. So, Your Excellency, we can see that in the present case regarding the Helms-Burton, this presumed rejection of the world community is not applicable anymore, since the European Commission has actually withdrawn this complaint, Your Excellency. And I would like to draw the court's attention to the fact that the principle of reasonableness has been applied by this court in several cases, as for example the fisheries jurisdiction case and the North
Agent, if two people in Caledon went through a marriage ceremony, would it not be the case that in the international community that marriage would be respected? Doesn't Caledon have the right to declare status in that sense and apply its family laws?
Yes, Your Excellency.
So if that's true, then why is it not also the case if Caledon decides to regularize the relationship between an adult and a child through an adoption procedure? Why is that not also a family law that is presumptively valid if done under the laws of the state of Caledon?
Well, Your Excellency, if the agents on behalf of the state of Caledon prove today to this court that they have a better basis for jurisdiction in this case, and that their jurisdiction will be more reasonable in the submission of this Laurentia, that we would agree with the court's ruling in that matter. However, Your Excellency, in the present case, we can see how Laurentia's jurisdiction would prevail for several reasons. First, Your Excellency, this Laurentia has lost a substantial number, or would actually lose a substantial number of its nationals because of Caledon's actions, speaking of the adoptions, Your Excellency. And this constitutes a direct offense against the state itself. In the second place, Your Excellency, these adoptions have affected Laurentia's nationals.
After the adoptions, would the children have only Caledonian citizenship, or would they be dual nationals?
Well, Your Excellency, there are not enough facts in the company that actually could show us if the children have dual nationality or not.
But if they had dual nationality under the relevant treaties and international law, then perhaps Laurentia hasn't lost anything. They could return to Laurentia when they're adults and take up their part in Laurentian society, as so many people have done in the world recently when they have been able to return to their native country.
Certainly, but they could not recover the family unity lost by the adoptions taking place in the state of Canada, Your Excellency.
Wasn't the family unity initially disrupted by the volcano? A lot of these children may not have a family.
That's true, Your Excellency. However, there is not enough evidence in the company that actually would show us that all of these parents are next of kin are dead. There might be some parents who next of kin of dead children in the state of Malaysia that have not been able to recover their children yet because, as my co-agent said before, of the vacant place given by the government of Canada to the state of Malaysia, Your Excellency. So, after analyzing the principle of reasonableness and analyzing the several principles or factors that the state of Malaysia invokes in Australia to claim jurisdiction in this matter, we must conclude that the state of Malaysia has jurisdiction to prescribe and to enforce the disabled children.
Does the Barcelona attraction case applicable in your presentation?
Well, Your Excellency, the Barcelona attraction case wouldn't actually apply in the present case of dealing with the enforcement of the decision, Your Excellency.
Why? Why not?
Well, since it is the mission of the state of Laurentia, Your Excellency, that in the present case that is dealing with the enforcement issue, the enforcement of the Global Achievement Foundation judgment, Your Excellency, we're dealing here with an issue of estoppel, Your Excellency. Since in the present case it is
How does this doctrine apply in this case?
Thank you for asking this, Your Excellency. In the present case, it is clearly stated in the company that it is the first time in the country's history that it refuses, speaking of Caledon, that it refuses to enforce a foreign judicial decision from a country with whom it has maintained friendly diplomatic relations. It is also stated in the company paragraph 1 that the state of Laurentia and the state of Caledon have had friendly diplomatic relations.
But can you establish that under international law, indeed, there is an international obligation to recognize the enforcement of another state's judgment?
No, Your Excellency. It is the submission of the state of Laurentia that in the present case, we're speaking of Laurentia and Canada, we're dealing with an issue of estoppel, since the state of Caledon has always enforced foreign judicial decisions from the state of Laurentia and the government of
But Ms. Hernandez, there really could never be something like estoppel when it comes to the question of recognition and enforcement of a foreign judgment, because the court will always need to look at the circumstances of the particular judgment, whether jurisdiction was appropriately obtained, whether public policy might be denied, and even if it has never come up in the past that those reasons were enough to deny enforcement of a judgment, enforcement of judgments is a discretionary matter with the courts in the absence of, as you've conceded, in the absence of any international convention that binds the countries or a bilateral agreement or any other kind of agreement. Surely there's no duty on the part of Caledon, just because problems haven't come up in the past, simply to rubber stamp judgments from Laurentia or anywhere else.
Well, Your Excellency, it is a submission of the state of Valencia that we are dealing with a principle, with a doctrine of estoppel here, and that has been applied by this court and recognized by this court.
In the context of judgment recognition?
No, Your Excellency,
No.
simply the doctrine of estoppel.
But the context may be very important when we're talking about estoppel, surely.
Certainly, Your Excellency, and that is why the state of Valencia has submitted to this court that it is an issue of estoppel. As said before, the state of Caledon has always enforced it, so we can see, Your Excellencies, how there is an uninterrupted, a historical conduct taking place by the state of Caledon of enforcing these foreign judicial decisions of the state of Valencia, and how there is a reliance of the state of Valencia in the conduct taken by the state of Caledon, that is, the enforcement of foreign judicial decisions of the state of Valencia. Since if the state of Valencia had not thought or believed or relied in the conduct of the state of Caledon of enforcing foreign judicial decisions, we would have probably negotiated some kind of treaty, Your Excellency, concerning the enforcement of foreign judicial decisions.
But surely in this contentious atmosphere that underlay the passage of this law, the state of Laurentia was well aware that the state of Caledon was not perhaps going to follow its usual procedures. If we were to disagree with you that estoppel could apply in this context, is there any other reason why the state of Caledon would have a duty to enforce the judgment?
Yes, Your Excellency. The state of Caledon has refused to enforce a judgment on the basis, on the grounds, that civil liability could not arise for officials that acted implementing a gubernatorial decree, because that would violate public policy. Your Excellency, nothing could be further from the truth, for several reasons. In the first place, the state of Caledon clearly refers to officials. Your Excellency, the social workers of the state of Caledon cannot be considered officials of the government of Caledon, and this is clearly clarified in clarifications of the case number 3. It is said that the social workers and Mrs. Montaigne are private citizens of the state of Caledon. And the second ground, Your Excellency, the Children Foundation is a private, non-for-profit international organization. It is not a gubernatorial agency, and this is established in the compromise, paragraph 20. So, Your Excellency, as we can see, the
what business did Laurentia have seizing their property then, since they were... would Laurentia take the position that it could just seize the property of any citizen of Caledon who happened to be in Laurentia because the government of Caledon has, in Laurentia's view, violated international law principles?
I'm sorry,
My problem is this. If there is some agency relationship between the Save the Children Foundation and Caledon, such that one could, in a sense, say that the foundation was part of Caledon, then at least it would still look like a government-to-government dispute where Laurentia was seizing some of the government's property. But according to your argument, they're entirely private, and on that rationale, it seems to me, the state of Laurentia could seize the property of anyone who was Caledonian in Laurentia to compensate for this injury. Is that right?
No, Your Excellency. It is clearly stated in the compromise that the Children Foundation was the organization that provided all the social workers that were to testify in the adoption proceeding. And
But
that
why
is-
did that violate, why was that bad? Suppose they had come in and they had said, we can find lots of parents, and we would like to do that. It's really the substance of their testimony that Laurentia is objecting to, not the fact that they testified.
Yes, Your Excellency, the State of Laurentia submits that it is the illegal nature of the adoptions, and that these social workers did not act in good faith, Your Excellency, since these social workers did not act with the due diligence necessary in these cases referring to the children and the adoption of these children.
Under what law did they have a duty to act with diligence?
Well, Your Excellencies, they were requested, or the social workers were requested to seek for the consent of the parents under the family law title of Oriente, that is Caledon, Your Excellency. So they were requested to actually find the consent of this parent in Laurentia and inform them of the adoption proceedings in the state of Caledon. It is clearly stated in the complaint that all these social workers did was send a letter by certified mail when an address was provided. Your Excellencies, I must remind the court of the situation in the state of Laurentia after the eruption of the Mount Zolo disaster. The sending of this letter cannot be considered enough due diligence, Your Excellencies.
Turning to another aspect, do you accept that there is some reciprocity in the recognition of enforcement of judgment?
Yes, Your Excellency.
Yeah, all right. Then if on that premise, you would accept if Caledon pass a law, follow the same process that you have done, compensation for the cigarette ban, they will also have obtained judgments, and these judgments will all equally enforceable in your territory, I presume, logically speaking.
Yes, Your Excellency.
Thank you.
If that were the case. Referring to my third submission to the court, Your Excellency, and that is the imposition of the import ban was in accordance with international law. It is a submission of the state of Laurentia that the GATT allows a contracting party to take all measures it considers necessary in order to protect its essential security interests.
Why should this court interfere with the dispute resolution mechanisms that are established now under the WTO?
Thank you for asking this question, Madam President, because it is the submission of the state of Laurentia that the ruling regarding this matter should be actually decided by the organization, the World Trade Organization, by the organs established by the World Trade Organization itself to deal with such matters. However, if the court decides to rule on this matter, I would be pleased to argue this issue. Yes.
Can you just inform the court briefly what has been the recent case before this court on a similar situation where another international organization is involved? Did the court act upon it, or did the court decline to exercise its jurisdiction?
My time has expired, Your Excellency, if I may.
Please answer.
Your question. Well, Your Excellency, regarding the issue of the General Agreement on Tariffs and Trade, and specifically the essential security interest, this court itself ruled in the Nicaragua case that it would not review the essential security interest because this was an issue non-reviewable by the court.
What happened in the U.S.-Iranian case involving the airplanes, and that the procedure is supposed to be dealt with by ICAO in the first place?
I'm sorry, Your Excellencies, but I am not familiar with that case. However, there are other cases in which the essential security interest has been applied, and this court has ruled not to decide on this since Article 21 of the General Agreement on Tariffs and Trade 1994 establishes that it is for the state itself that departs from the treaty to decide what national security interest is. If I can be of any further assistance, Your Excellency, any questions?
Thank you very much.
Thank you very much.
As first agent, I will argue first that Laurentia is barred from pressing a claim before this court due to the failure of its nationals to exhaust all available local remedies. Second, that Caledon has complied with all of its international legal obligations. Most importantly, Caledon has consistently acted in the best interests of these children.
Mr. Thiessen, how could the nationals of Laurentia have participated in the adoption proceedings that took place in Caledon when, to put it mildly, the notice that Caledon chose to give these people was not very aggressive? Most of them probably had no idea that these proceedings were taking place, if there are in fact interested people in Laurentia.
Madam President, on the issue of local remedies, there is a duty upon states, upon nationals of the state, to exhaust all available local remedies prior to their country having a claim before this court. However, Laurentia could seek to invoke a futility claim. The issue of notice, as towards a futility claim, would require that Laurentia prove both that Caledon failed to provide notice to these parents and that lack of notice rendered the remedy futile. Ample authority for this onus of proof can be found in footnote 5 of the Respondent's Memorial and includes such opinions as the separate opinion of Justice Laurentia in the Norwegian loans case and such learned authors as Professors Amara Singh and Trindade. Your Excellencies, notice and consent is, however, a relevant issue as towards Caledon's customary and conventional obligations at international law with regards to children.
Do you think Article 7 of the CCA Abduction Convention is applicable in the present case?
Your Excellency, the Hague Convention on the Civil Aspects of Child Abduction is generally not applicable in this case, as it is not properly invoked before this court. That is, Laurentia has sought to seek the return of the children under the Hague Convention based on the fact that the Hague Convention requires one natural parent to return the child to another natural parent if they both hold custody rights. However, Your Excellency, in our situation, we have a unique one. That is, Caledon actually provided emergency care and evacuation for these children. It has been thanked for these actions by Laurentia. However, the Oriente family law courts are placed in a unique situation in which Laurentia is asserting that they should have had the children returned, but no one holding any custody rights to these children have presented themselves to the proper authorities in Caledon, in the Oriente family law courts, asserting such a return.
But Mr. Thiessen, it's very common or abused or in other circumstances in need of assistance for the state itself to become their guardian for some period of time. And I don't see why this is necessarily so different from the normal situation you described for the abduction convention. The children were under the guardianship of someone in Caledon. Now the state of Laurentia, in place of a natural person guardian, comes forward and it says, thank you very much, we're glad you took care of the children, but we're ready for them to come home now. Why is the analysis different depending on the identity of the guardian?
With respect, Madam President, the analysis is the same. What is highlighted by this is that the state of Laurentia claims that it has some parents' patriae jurisdiction over these children, that gave it some inherent right to claim custody rights for these children. Your Excellencies, with due respect to the submissions of the agents for Laurentia, this is simply not so. Parents' patriae is a general principle that exists, which allows states to protect those who cannot protect themselves. Laurentia could only invoke the parents' patriae doctrine before a Laurentian family court to establish before that court that it had custody rights over the children. After doing so, and only after establishing proper custody rights, could the Laurentian government come before the Oriente family law courts and ask for the return of specific children.
Isn't that a matter of Isn't that a matter of internal Laurentian law, such that if Laurentia has decided that the government of Laurentia is now in a position to assert those rights, we accept that. We don't look in to see whether some agency in Laurentia should have gone to a local court. They've now, for international purposes, come to that conclusion.
Your Excellency, it is only important because Laurentia is seeking to invoke the Hague Convention, and the Hague Convention requires that the courts look into custody rights. That is, in all municipal decisions of the courts of such countries as Canada, Israel, United Kingdom, United States of America, and Australia, the courts will consistently require anyone claiming a child before that court for return of a child to another state that they first prove custody rights. This is a very important factor, Your Excellency.
Do I understand you correctly that you are not invoking the three international instruments, that they are not applicable in the present case, or do I understand you wrongly?
Your Excellency, it is Caledon's submission on the three instruments before this court that on the Hague Convention on the Civil Aspects of Child Abduction, that convention is improperly invoked before this court.
And the other two?
And if it was properly invoked, that we fit within the exception. On the Convention on the Rights of the Child, this was not a binding treaty obligation as between Caledon and Laurentia at the time the dispute arose. However, as Laurentia has only submitted two principles from the convention, that is, a principle of customary international law that Caledon act in the best interest of the children, and that Caledon provides some notice to the parents of the children, Caledon submits that it has fully complied with any customary obligations evidenced by that convention.
I did understand you referred to these principles as general principles. Could you tell the court, and then under which statute, the ICJ statute, Article 38, doesn't these general principles should be taken into account by the court?
Yes, Your Excellency. Article 38 of the Vienna Convention does state that...
Did you say Vienna Convention?
I'm sorry, Your
Of the
Excellency.
statute of the
Yeah,
court.
the statute of the court states that customary international legal obligations should be taken into account by this court. We should therefore turn to the customary international legal obligations owed by Caledon. First and foremost, Caledon, as with all states at international law, owe an obligation when making decisions with regards to children to consistently act in the best interests of those children. Caledon has done so in proceeding with adoption proceedings, and this is evidenced by several factors.
Before you get into that, let me ask you maybe a simpler question about this situation. Suppose there had been a family where the mother and father split up, and the father went to Caledon and the mother stayed in Laurentia, and initially with consent, the child of the broken up marriage went to Caledon with the father. And then at a later time, the mother, perhaps even under a decree, so I'll make it easy, says, now I have a right for the child to be returned to me. Would it be your position that the courts of Caledon could look into whether it's in the best interest of that child to go back to the mother in Laurentia under those circumstances? In other words, could they override the Laurentian court decree that gives her that right, or should they simply enforce the arrangement that had been made?
Madam President, in that situation, we would look at such factors as the several exceptions under the Hague Convention. These exceptions are designed such that states are able to protect the best interests of the children. In the situation before us, we can look at the fact that...
So in other words, you're saying that Caledon could reevaluate whether it was in the best interest of the child in my simple situation to go back to Laurentia with the mother. And if the courts of Caledon thought that the mother was an undesirable custodian for the child, they could simply refuse to send the child back. I just want to make sure I understand your position.
Not quite, Madam President. What the courts, the family law courts in Oriente province could do, however, is look at such exceptions such as if it had been 1 year that had elapsed since the child had been removed, and whether that child had become well settled in their new environment.
But in my hypothetical, it's been 3 years. The child goes and lives in accordance with a Laurentian divorce decree for 3 years with its father in Caledon, and the Laurentian divorce decree says now you go back to Laurentia with your mother for the next 3 years.
Yes, Madam President. In your scenario, the situation would be one where the mother would come to the state of Caledon with request of the Oriente family law courts that the child be returned. Those family law courts would ask that the mother present proof that she had custody rights over the child. This could include such information as a court order from the Laurentian family law courts that she did indeed have custody rights.
Looking at this case also at the international level, here we're dealing with 400 cases. 320 has already been settled by you. Please explain to the court, how do you say that you have dealt with in the best interest of the children from the point of view that you are giving them a different religion, different language, different nationality, and different education system? How do you ascertain, in the absence of their parents, that these are really in the interest of these children?
Your Excellency, in looking at the best interests of the children, we have to balance the factors before the court. And that is, the first factor before this court in evidence is that the independent family law courts in Oriente province considered individual petitions for the adoption of each of the 400 children.
Isn't that very subjective, that your court judge according to the court's value over these children, rather than looking at from the background of the origin of these children in terms of their language, education, religion, and so on?
With respect, it is not, Your Excellency. Family law courts of nations consistently look at what factors should be considered in looking at the best interest, and they will, although the best interest principle is a flexible principle, they will often look at the religious or traditional background of a child.
But they weren't required to, were they, in Oriente?
With respect, Madam President, they were required to.
To look at the language, cultural background, nationality, origin?
With respect, Madam President, it states that Caledon holds an overriding obligation of international law to act in the best interest. Case law suggests that states should consider all of the factors applicable in each case and should apply due weight given in that case. This is outlined by authorities such as Diane passed in evaluating preeminent case law from around the world. Your Excellencies, it can therefore be assumed that the family law courts in Oriente province would have considered all the factors before it when conducting the adoptions. Indeed, this objectivity is evidenced strongly by the fact that this court sent back some 80 petitions for reevaluation.
Would it be necessary, in order to get a clear picture, that one at least tries to find relatives of the children concerned, and this would mean that more information must be given to Laurentia, and in order to give possible relatives the possibility to take part in these proceedings. You will always insist on the fact that this is considered to be in the best interest of the children. As far as we can see from the files, in none of these 400 proceedings, any persons from Laurentia, any relative, could take part. This indicates that there has not been more information, so that the Laurentian authorities could try to find relatives. Don't you think that a proper procedure in the interest of the children requires that one at least tries to get also information from those persons who might have family relations with these children?
Your Excellency, there is some obligation under international law to provide notice and consent from the natural parents of children. However, Caledon submits that it fulfilled these obligations. Caledon, according to section 3.064A of the Family Law title, allows these parents to participate in adoption proceedings within its province. Your Excellencies, in taking notice and consent, Caledon compiled a list of all available information on the children. It placed that list in its capital and informed Laurentia of the list through diplomatic note. In addition,
But when you say it compiled a list of all available information, I think that the question is really, as we were discussing with the agents for Laurentia, how much of a duty was there on Caledon to take affirmative steps to develop information about these children? If it was a 3-year-old child, you can't say, give us all the information about your family, but perhaps there would be photographs, perhaps there would be sources in Laurentia, perhaps aid workers could have helped. How hard did Caledon try to develop information so that the notice could be meaningful?
Madam President, in answering your question, I must first outline what the standard of notice would be. Under Article 21 on the Convention on the Rights of the Child, it is important to notice that notice must be provided in accordance with applicable law. In this case, the law within Oriente Province.
No, but suppose Oriente Province said, if you publish the notice in the newspaper of general circulation in the capital of Oriente, that's enough. Well, that would not be enough to reach people in Laurentia, and there are broader principles of due process and of notice that would come into play. The convention didn't mean publish one little notice that no one will ever see. It has to mean meaningful notice.
Yes, it does, Madam President. Indeed, those actions by Caledon or Oriente Province would be enough to comply with the Article 21 of the Convention on the Rights of the Child, because they would be enough to comply with the Oriente Family Law title. However, as the agents for Laurentia correctly pointed out, there is some evidence that international law of standards for tracing of children. However, what the first agent for the state of Laurentia failed to highlight is the fact that in all of these incidents, in every incident at international law where a child has been removed or evacuated from their place of habitual residence, there are 2 states involved. This is highlighted by the Rwandan refugee situation of 1994 and 95. In that situation, we had one where there was a civil war going on, and perhaps almost all government structures had been eliminated. Your Excellencies, the International Red Cross and the UNHCR in that situation required participation by the Rwandan government, even though other states were seeking to make some tracing efforts.
In that case, did it involve divergences between the 2 countries in terms of their religion and their cultural background? Did you, for example, made an effort to tell the children that tomorrow morning they don't have to say their prayers and they can unveil their face instead of covering their face? These are very significant differences for these children. What kind of effort have you made in order to really to educate the children make them aware of their original cultural values?
Your Excellency, although there is no evidence in the compromise as to what efforts did or did not take place on behalf of the Oriente government to educate these children, it does state in paragraph 7 of the compromise that the Caledonian, specifically Oriente provincial government, has protected the right to religious freedom in disputes with the federal government of Caledon. We can therefore assume that the Oriente provincial government strongly protects the rights to freedom of religion, and that rights to education in those religions would be protected.
Now, these step-parents, are they going to educate these children in their own religion or in the religion of the origin of these children?
Your Excellency, once again, we simply do not know as to which religion these children will be educated in. However, there is nothing insignificant or less satisfactory to the religion and beliefs held by Oriente families, and there is no evidence that those families would not as strongly value the religion and beliefs of Laurentian parents or Laurentian families and bring those children up with an equal opportunity to learn both cultures.
Well, there is actually some evidence that suggests to the contrary, since a majority of the people of Oriente have voted to put in power a political party that seems to take quite a different view. The public institutions in Oriente will adopt various policies that affect cultural values. And of course, even if legislation hasn't been passed yet, there is certainly some evidence that the children will be in quite a different cultural milieu in Oriente or Caledon than they would have been back home in Laurentia.
With respect, Madam President, the evidence from the compromise states only that the Way of Righteousness Party, on its political platform promises on the way to election, made some political platform promises to restrict some rights to higher education.
Significant rights. We can't underestimate what they were talking about doing.
And career pursuits.
We cannot underestimate the value of these rights, but what we can do is look at the facts. First of all, there have been no restrictions of these human rights within Oriente province.
But in taking into account the best interest of the child, we're always predicting the future in any event. Why isn't this a prediction of the future that suggests rather strongly that the interests identified in the Rights of the Child Convention will not be respected in Caledon, in Oriente?
Madam President, it is important to note that, first of all, we are weighing these against the other evidence that shows that it's in the best interest of these children to remain within Oriente province.
Is there anything but economic interest that tells that? We can assume from the compromise, I think, that the children are being materially provided for in Oriente. But what else suggests that this is in their best interest?
Madam President, as these children have been placed in foster and adoptive homes for upwards of 3 years, it is also reasonable to assume that they've been provided with both their physical and emotional needs, and that these children would develop significant attachment to their adoptive parents. Indeed, this is evidenced by such experts as Professor Goldstein, Anna Freud, and Albert Solnit, who state that children who are adopted into homes may develop more significant attachments to their adoptive parents than their natural parents for children under the ages of 14 after a period of 24 months. Your Excellencies, I see I'm out of time. If I may finish this question?
You finish your statement, yes.
Your Excellencies, for children under the ages of 3, the maximum period after which children develop more significant attachment to their adoptive parents is a mere 12 months. Therefore, this is strong evidence that these children, who've been in their foster and adoptive homes for upwards of 3 years, would have developed significant attachment to these adoptive parents. One final point which illustrates why it is in the best interest is that these children suffered significant psychological harm upon being evacuated during the Mount Zolo eruption, that is, due to the volcanic eruption in Mount Zolo. Your Excellencies, they received psychological care within Caledon. These children are therefore even more fragile than the children that Professor Goldstein highlights, and we should not remove them, for many of them, from the only homes they've ever known.
Thank you, Mr. Thiessen.
Thank you.
Mr. Sankoff?
Good evening, Your Excellencies. I'll make 3 specific submissions. First, that Caledon is entitled to profits loss as a result of the cigarette ban. Second, that the Save the Children Act is impermissibly extraterritorial. And finally, that Caledon has no obligation to enforce the judgment of Laurentian courts in the Doe case. Turning to my first submission with respect to the cigarette ban. Your Excellencies, this court does have the jurisdiction to entertain matters concerning the general agreement on tariffs and trade.
Mr. Sankoff, there are 2 questions that this court needs to consider, though. One of them is the one that you've articulated. Do we even have the jurisdiction, given the well-developed dispute resolution mechanisms that are now available in the WTO, which were very much elaborated after the Uruguay round? And the second one, I think, is a more discretionary question, whether, in light of the very complex system that the general agreement now has, and that entire system is characterized by, whether this court should take a step which might interfere with a very delicate balance of remedies and counter-remedies that the WTO system has.
First, Madam President, there is nothing in the WTO which precludes the jurisdiction of this court. And indeed, if we are to assume, and I assume correctly, that Article 34.3 of this court statute has been complied with, then the WTO should be aware of the proceedings before this court and would have had the opportunity to make submissions to this court with respect to the adoption or the interpretation of its constitutive articles and statute. And so it would appear, if we assume that Article 34 has been complied with, that the WTO has no objection to this court entertaining jurisdiction.
Can you
But
cite in your, sorry.
I was just going to say, the thing that bothers me about that is if one looks at the negotiating history of the dispute settlement mechanism in the WTO itself, few things are more important than the question of remedy. If there is a violation of, say, the quantitative restrictions ban, or if a tariff binding is violated, or if any of the many other provisions are violated, there's a very elaborate balance about under what circumstances countermeasures can be taken, retaliatory measures, if you want to call it that. And if this court were suddenly to come in and start giving orders of damages, that would upset that balance in the face of these very carefully negotiated arrangements. And that's my real concern, because certainly it is another international instrument, and we have to construe it if, as you're suggesting, it's even before us at all.
Madam President, the dispute resolution system created by the dispute resolution understanding in the recent GATT negotiation is a voluntary set of dispute resolution procedures, and that two parties may still, pursuant to Article 36 of this court statute, submit their dispute for the consideration of this court, particularly when the dispute involves political considerations, matters of customary international law, and other areas that are at least beyond the expertise of the GATT WTO organization. Now, with respect to a concern that there might be floodgates open because of this, which I understand to be part of the concern that you have addressed, Madam President, certainly the floodgates have been open now for almost 50 years. Under the prior GATT, there was certainly a voluntary dispute resolution procedure, and only once was the question of GATT obligations brought before this court, which was in the Nicaragua case. This court did not decline jurisdiction, however, on the basis that it could not examine the GATT, but rather because of a multilateral treaty reservation that was entered by the United States. So with respect then to GATT or WTO, we do not need to concern ourselves that this court will suddenly usurp the jurisdiction of the WTO, as the majority of trade disputes between states will involve technical commercial trade disputes that the WTO has truly the expertise to deal with. If there are no further questions on the jurisdiction of this court to entertain the GATT, I will move now to the substantive issues of law that have arisen under it. Laurentia is prima facie in violation of Article 11 of the General Agreement on Tariffs and Trade, and therefore the only question before this court is whether or not it can be justified under Article 21, which Laurentia has asserted both in its memorial and in oral argument, or as a non-forcible countermeasure. Laurentia has also raised the issue of self-protection of nationals under Article 51 of the Charter, which I will address. Turning first to the Article 21 security exception. This exception is used by the contracting parties, and has been used by the contracting parties, in times where there has actually been a use of military force, or when there is an impending threat of the use of military force.
But isn't the principle, though, whether this court is in a position to second guess, or for that matter, a WTO panel is in a position to second guess a nation's declaration of its internal security interests?
Your Excellency, the test indeed is not an entirely subjective one. That is, Laurentia must have some latitude in determining what is in its essential security interests.
What could possibly have been against the national security interests of the United States in the Nicaragua case? Was Nicaragua going to invade?
No, Madam President, certainly not. Nevertheless, there was an involvement there of military force between Contra and Sandinista forces, which apparently the United States was involved in, as well as the threat, as it was perceived then, of the Cold War and world communism.
But why was that a national security interest? In other words, when this court decides not to look into an assertion of national security interest, why can we look into the national security interest under the facts before us? Surely vast movements of population, such as have been happening in Rwanda, such as have been happening in other parts of the world, present security interests every bit as significant as some mines in the harbor.
Madam President, this case does not involve, in imposition of a trade sanction with respect to the mass movement of populations, but rather with respect to the adoption of Laurentian children in Oriente province.
But you're just redefining the Laurentian point of view. From Laurentia's point of view, a significant number of its population, 400 children, have been taken away and, upon request, not returned. Are you saying that countries can just go take 400 of some other country's citizens and keep them?
Madam President, Laurentia did not object to the evacuation of the children.
Yes, but they're objecting to the retention.
Of course, Madam President. However, it must be remembered that Article 21 has been used not for the purpose of protesting human rights violations, but where there are examples of actually military security interests involved, no matter how slight. In the present case, there is no question that there is no military security interest involved.
But that's where I'm having a problem with your argument, because if you agree that Laurentia is objecting to the retention of 400 of its children, and we all agree that children are a very important part of the population, they're the future, Laurentia wants the children back. There are significant implications to keeping members of another population. There are brain drain population concerns, and I don't see where the clear line is that you're trying to draw between forcible population relocations in the sense of this retention and other kinds of national security threats.
Your Excellency, the simple fact that 400 children have been adopted in the state of Caledon does not give rise to a security interest, as otherwise any adoption of any child, contrary to what Laurentia perceives to be its right to determine what is in the best interest of the child, would allow Laurentia to impose the Article 21 security exception and to evade its GATT obligations. It must be remembered that when there is a prima facie violation of the GATT, it is up to the party invoking an exception to prove that it falls within the exception.
But Laurentia's not arguing a one-child case. Laurentia's arguing a mass population case. Would we need to rule in a way that covered the one-child case?
That would be a matter for the parties in that case to determine, Madam President.
Right. We wouldn't have to reach that.
I'm sorry?
So, yes, so you agree we would not have to reach a case where it was simply one child, where we have a case here where there's been a very significant number of people retained over the objection of the country that we all agree is the country of original nationality of these children.
Nevertheless, Madam President, it is for Laurentia to show that there is an emergency in international relations, which is an objective standard under Article 21 of the GATT.
You don't think there is that criteria has been satisfied in the present case? When you have 400 children being taken away, given different religion, a different nationality, different school system, different education, and their future will be limited, their career will be restricted, discriminated. Of 400 cases, you don't think that constitute a serious consideration for one country, that they have to take certain measures?
That is certainly a serious consideration for a country, Your Excellency. Nevertheless, it does not fall within what the parties to the GATT have defined as an emergency in international relations.
What about, with the permission of the President, how about looking beyond Article 20 or 21? Does international law permit countermeasures or reprisals? Could you elaborate on that?
It does, Your Excellency. Non-forcible countermeasures are permissible in international law, but only if certain conditions have been met. And the first and most important of these, of course, is that there has actually been a breach of international law by the state against whom the countermeasures are directed. And there has simply been no breach of international law by Caledon, as my co-agent has already argued.
If the court determined that the retention of these children are a violation of international law, then this would be acceptable under international law.
No, Your Excellency. There is a further requirement that the measures must be proportionate to the original breach. And this proportionality requirement has been defined to mean that a state cannot take permanent measures which will cause permanent damage to the offending state until it has first taken steps which will be of a non-permanent nature.
But who took the permanent measures? Surely a temporary monetary loss for a state is just that. The state will recover from it. Nothing has changed. whereas keeping the children for potentially the rest of their lives is truly a permanent change.
Madam President, the imposition of trade sanctions by Laurentia cannot be called a temporary measure simply because the import ban itself only lasted 6 months. The question is whether or not the harm that is caused by that cigarette ban is permanent. The losses that were suffered by the Caledonian cigarette companies cannot be recouped unless this court is to award damages to the state of Caledon today.
Well, that's not the way. I mean, here we get back to the nature of the violation. If it's really a quantitative restriction that you're arguing about, to come up with now the theory that virtually any kind of retaliation is okay or any kind of remedy is okay takes us beyond that set of remedies that the WTO itself prescribes for the violation. And it seems to me that's, even if there's jurisdiction, if we're applying an international instrument, namely the General Agreement, why shouldn't we be required to look at the set of remedies that instrument itself sets forth for violations?
First of all, because there is nothing within the WTO dispute understanding which precludes other remedies being adopted by the parties. The WTO dispute understanding is not exclusive.
By the parties is rather different from another remedy being announced as the appropriate resolution by the court.
I'm sorry, Madam President, I didn't understand the question.
Well, if the parties agree to a different resolution, that's one thing. If a court imposes a different resolution on them, such as a damages remedy here, that's quite a different way of resolving the dispute.
Those are certainly two different remedies, Madam President. Nevertheless, the fact that damages, or that compulsory damages, may not be ordered under the dispute settlement understanding does not mean that compulsory damages cannot be imposed by the court here. The reason is that the remedy described in the dispute settlement understanding is not intended to define a substantive remedy, but rather is intended to define the competence of the WTO. And since the remedy...
But you would agree this was a meticulously negotiated part of the WTO agreements. There was great attention paid to exactly what the remedy structure was going to be.
Certainly, ma'am.
And because of that, I'm not sure I agree with your assumption that the fact that there wasn't an extra clause at the end of it saying, and we mean to exclude other remedies such as damages, means too much. There was a very careful balance drawn.
It is precisely because there was such a careful balance performed, and because the parties did take so much attention to the drafting of this particular agreement, that it would have been easy for them first to exclude the jurisdiction of this body specifically, and second to provide that no other remedies would be allowable, but rather use words such as the party shall be able to resort to the dispute settlement procedures that are contained in this understanding. Therefore, if the parties do decide to go outside of the WTO and bring their dispute before another body, such as this one, which has the inherent jurisdiction to award damages and has the ability to award compensatory damages, then certainly the parties have agreed that such a remedy is acceptable in the case.
Factually, am I not correct to understand that, in fact, the investors, most of them are from the Laurentia, and I hope you address the question of damages to the court in due course.
It is not precisely correct, Your Excellency, that most of the investors are in Laurentia. Rather, the compromise states that many of the cigarette companies, have Laurentian investors in. None of the cigarette companies is controlled by Laurentian investors. Nevertheless, and in any event, lost profits are obtainable as a remedy of international law, as is evidenced by the Martini case, in which a Venezuelan blockade resulted in loss of profits to an owner of a mine, and that owner was able to recover those lost profits. Similarly, as was pointed out by the predecessor of this court, in the Wimbledon case and in the Chorza factory case, the damages are an automatic remedy where there has been a violation of international law, that the violation gives right to a remedy. In the present case, the damages are specifically quantifiable, and therefore this court should be able to award damages for lost profits. Your Excellencies, if there are no further questions on the subject of Caledon's claim for lost profits, I'll turn now to my second submission, which deals with the Save the Children. Your Excellencies, the Save the Children Act is impermissibly extraterritorial, and it is so for a number of reasons. First, the adjudicated jurisdiction claimed by the state of Laurentia is impermissible at international law. And second, Laurentia has taken steps which asserts its prescriptive jurisdiction impermissible.
We have to take the prescriptive jurisdiction first, I think. Why is Laurentia not entirely entitled to prescribe rules about its own nationals, the children in this case?
This is a critical point, Madam President. Although agents for the state of Laurentia have justified or have rationalized the jurisdiction claimed under the Act as being based on the effects principle or on the objective territorial principle, in fact, the only base of jurisdiction claimed by the legislation itself and in the legislation itself is the passive personality-based jurisdiction.
Well, they also claim nationality-based jurisdiction. I think it's not just passive personality. It's because the children are nationals, just as if nationals of Laurentia had a duty to report for military service. Even if they happened to be in another country, they would still need to go back home to Laurentia to report for military service. These children were nationals of Laurentia, and Laurentia was able to prescribe rules for their protection.
Madam President, I'm afraid perhaps that I'm using a different terminology and have made myself unclear. The nationality principle, as it is used by the state of Caledon, refers to the prescriptive jurisdiction for a state to tell its nationals how to conduct themselves abroad. But when a state asserts jurisdiction over individuals whose wrongful acts harm the nationals of the state, that is the basic jurisdiction that Caledon refers to as passive personality.
Sure, no, I understand that, but I think that in this case, the fact is that the children themselves, people are took actions in Laurentia, and they took the children away, and they are trying to change the status of the children, focusing on the adoptions. And I think in that sense, it's a more conventional nationality principle. It's not only the passive personality, which would be the harm to the nationals abroad branch of jurisdiction.
With respect, Madam President, Caledon would assert only that the nationality principle, known as the active nationality principle, could be applied by Laurentia only if it was attempting to prohibit certain acts by those children while they're in the state of Caledon. That notwithstanding, the principle that a state can legislate with respect to the acts of foreigners that are taken against its nationals has been rejected at international law, specifically for ordinary torts and crimes. Now, the Lotus case, which was referred to by agents for the state of Laurentia, does not support the passive personality principle, as the court did not decide the case on the basis of passive personality, but rather on the basis of objective territoriality.
Turning to your assertion of this principle of passive personality, is it not correct that according to state practice, that principle in fact applies to only very limited cases, but nothing comparable to the present case?
That is correct, Your Excellency. That a state may not assert passive personality jurisdiction in a case such as this, where at worst, the actions of the Caledonian social workers could be described as professional negligence. Passive personality may be used for such acts as political assassination or hijacking, but may not be used for ordinary torts and crimes. Indeed, its base as a source of jurisdiction has been questioned altogether. For example, by the League of Nations Committee of Experts for the Codification of International Law, and by such authorities as Brownlee and Mann, and also by the states, by state practice itself, in enacting such conventions as the 1956 Geneva Convention and the 1982 Convention on the Law of the Sea.
What about here? You have the governor's decree. Is it not an official act that can be considered in that category?
It is not necessary to consider that specific question, Your Excellency, as the governor himself is not subject to liability under the Act. What the Act does is it allows individuals in Laurentia to assert liability and to assert jurisdiction over individuals in Caledon, particularly social workers.
With respect to their acts in Laurentia, though, at least in part, because what it says is that it's the testimony of the social workers before the Caledonian courts, but presumably the social workers were doing their investigation of the adoption proceeding in Laurentia to see if there was any family. That's what we were told by your co-agent, that there was some effort to find out where these families were. Please answer the question.
Madam President, simply there is no evidence in the compromise that any of the social workers who are subject to liability in the state of Caledon for acts performed entirely in the state of Caledon ever visited the state of Laurentia or ever acted or committed any element of the offense that is described in Section 301 in the state of Laurentia.
It seems that that's devastating to your notice argument, but perhaps maybe on Sir rebuttal we can hear about this. If you'd like to conclude, that would be fine.
If I may respond to your question, Madam
Sure.
President, simply that the acts, the wrongful act alleged by which is the participation in the adoption proceedings. Sending letters to the state of Laurentia is an act that takes place in the state of Caledon. If I can be of no further assistance.
Fine, thank you very much. We'll now hear from the applicants on rebuttal.
But repeat is on report. The applicant state will now exercise its right for rebuttal in 3 minutes. Your Excellency, we will contest some of the main issues raised by the respondents that have caught our attention and hopefully yours as well. The first of which, Your Excellency, is that under the case concerning the application of the Convention on the Prevention of the Crime of Genocide of 1993, this court established that states have the right to exercise the right of parents patria over its citizens. Usually, I assume that respondent state is not aware of the case. Your Excellency, respondent state has also argued that only 2 violations of the Convention on the Rights of the Child have occurred. However, I would like to cite, first of all, Article 3 concerning the best interest of the child that has not been taken into consideration. Article 8, preservation of identity and cultural heritage that has been breached. Article 12.2, the right of the child to be heard in judicial proceedings, not taken in care in this case. And Article 21b, calling on inter-country adoption as a last resort, although respondent states use it as a first resort. Your Excellency, under the states have the clearly right to establish whatever legislation they want. However, the respondent state has argued that no legislation discriminating women has been enacted. However, we must ask ourselves, have laws been passed in order to outlaw discrimination against women? No, Your Excellency, they have been not. Concerning the General Agreement of Paris on Trade, Your Excellency, it is the submission on behalf of the state of Laurentia that this court has no jurisdiction over the matter. For Article 9.2 of the Marrakesh Agreement establishes clearly that this dispute should be heard within the GRAD framework. However, if this court wishes to hear the case, the ban itself is legal, for it is in accordance with Article 21b(3) of the GATT. However, Your Excellency, the respondent state has started to argue that military reasons must occur in order for a state to guarantee its essential security interests. However, there are several cases under international law on which import bans have been accepted even though no military threat existed. Such are the cases of the embargo against Cuba, the embargo against South Africa, and the case of the United States versus Czechoslovakia. And in the last submission by the applicant state, it is that the GATT does not have any provision whatsoever for loss of profit. And Your Excellency, this is a treaty that is binding between the states, and as provided under Article 338 of the Statute of this Court, Paragraph 1, Subsection A, it is a source of law that should be taken care by this Court, Your Excellency. If I may be of further assistance with this Court?
May I just ask one question? You asked for the return of the children and also compensations. What happens if the court cannot grant on both grounds? What would be your choice, if you have a choice?
The return of the children, Your Excellency. Thank you very much.
Thank you very much. And we will finally hear from the respondents on their Sir rebuttal.
Your Excellency, with respect to the right to be heard in adoption proceedings, there is no evidence in the compromise that children were not or were given any right to participate in the adoption proceedings. There's simply no evidence in the compromise, and the Laurentia cannot assert that the children were not allowed to participate. With respect to the jurisdiction of this court under 9.2 of the Marrakesh Agreement, this law essentially codifies what was the old law of the GATT, and and that is that it is only the GATT Council that can adopt interpretations of the GATT that are binding on the GATT parties. A decision of this court would not be binding on all of the GATT parties, but only as between the two parties before this court today. With respect to I cannot address all of the points of Laurentia in this survey. However, with respect to the use of Article 21 security exceptions, agent for the state of Laurentia represented to this court involving sanctions against the state of South Africa. It is important to note that in 1985, the Security Council of the United Nations recommended that certain trade sanctions, particularly embargoes, or a ban on the sale of crew brands, be adopted by the member states. Nevertheless, Canada, the United States, and the European Union declined to impose these measures, but rather only asked for a voluntary restriction on the sale of crew brands by its population, as in the words of Secretary of State George Shultz in the September 1985 press briefing, we have certain GATT obligations and these cannot be breached. Unless there are any questions, those include the submissions of Caledon. Thank you.
Thank you very much. The court thanks the agents for both Caledon and Laurentia. The case will be submitted and the court will take a brief recess.